The African Court on Human and People's Rights is a tribunal established to ensure the protection of human rights across the continent. The court recently celebrated its 10th anniversary. It set up in Addis Ababa, Ethiopia in November 2006. But in August 2007, its headquarters moved to Arusha, Tanzania. The first decade has been filled with challenges. 30 out of the 54 member states of the African Union recognize the court, but only 7 allow NGOs and individuals to bring cases before it. But perhaps the biggest challenge is that Africans don't seem to know the court exists. So has it failed? What has the court accomplished so far? And how will it move forward to guarantee human rights are protected across Africa? To find out, we sit down with the President and Vice President of the African Court on Human and People's Rights. Justice Sylvain and Justice Ben Kyoko talk to Al Jazeera. Over the last couple of days, we've been speaking to many Africans, and we also ran a poll on social media, and the vast majority tell us that they have never heard of the African Court of Human and People's Rights. Why do you think that is? And can you do your job effectively if people don't know that you exist?
It's a very big concern indeed that the court is not well known. What we have planned since 2010 is to have sensitization missions throughout Africa so as to make the court well known, its mandate, its jurisdiction.
You have this mandate to assert the rights of victims of human rights abuses. What examples can you point to in which the court has addressed this?
We have achieved a lot, I think, in terms of addressing concern of citizens.
Can you be more specific? Which countries could you point to where?
Yes, about freedom of expressions. We have some cases against Burkina Faso. I think you know Norbert Zongo was one of the journalists murdered in Burkina Faso.
It's been 18 years since investigative journalist Norbert Zongo was murdered in Burkina Faso, then ruled by a military regime. The case remained untouched for years. In fact, it is still unsolved. But in June 2015, following an appeal by Zongo's family, the court ordered the government to reopen the investigation. So what's happened since then?
Fortunately, Burkina Faso has complied with the order, with the judgment we made, and the victim has been satisfied with...
Have people been arrested?
With regard to the investigation, it's still ongoing. But with regard to the reparation, the state have complied with the reparations.
Among the 30 African states that have signed the protocol that created the African Court, 7 countries have supported the declaration in it that allows individuals and NGOs, rights groups, direct access to the court. 7 countries. Are you happy with that level of success after 10 years, that level of progress?
That is 8 countries that has made the declaration to allow individuals and NGOs to have direct access to the court.
Well, one of them is about to withdraw, isn't that right?
Yeah, one have withdrawn, Rwanda exactly, but the withdrawal will take effect 1 year after the notice of the withdrawal, and the notice was in February 2016, so till February or March 2017, this withdrawal will take effect.
Why is it only that number that have signed on to this, that have allowed access for individuals and NGOs?
The biggest reason, perhaps we can say that all states are sovereign to make the declaration. Sometimes they take times to make this declaration, and we can say that because when we go for sensitization, we approach the political the person who made the decision at the political level, sometimes we succeed. All these declaration, the major declaration that have been made is because of the sensitization mission we have undertaken in these countries.
It sounds like you're saying then that there is a lack of political will on the part of African states to empower your court.
A lack of political will in a sense, but we can say that in a certain extent, but also, as I said, when we go on the ground to visit or to approach the political people who take the decision, we can see that they make the steps to make that declaration.
We spoke to a number of human rights groups, and one of the criticisms that they brought up about your court was the slow pace of decisions that are made in many cases when the case comes to your court, and then the time between that and when a decision is finally made takes as many as 2 years, sometimes longer.
Many reasons can explain the delay in the delivery of judgments. The first reason is the fact that the judges are working on part-time basis.
Sorry to interrupt, but why are they working part-time? Why is that? Is that an issue of resources? Is that an issue of funding?
No, it's a protocol. In the protocol, it is stated that the court, the judges are on part-time, and only the president is in full-time.
Let's talk about the ICC, the International Criminal Court. South Africa, Gambia, and Burundi have announced their intention to quit the ICC. Are you expecting that or fearing that will be a trend? Are you expecting an African exodus from the ICC? And if so, is this something that the African court can step into here? Is this a void that your court can step into?
There is a crucial difference in the mandate of the African court and the ICC, because the ICC deals with criminal crimes under the Rome Statute protocol, as you know, genocide, crimes against humanity, aggressions, and war crimes. The African court complies with the mandate is against states for violations of human rights.
Sorry, forgive me, but that sounds very similar. I mean,
yeah.
The human rights, the ICC has taken up, I mean, to a layman who's not familiar with
yes.
the legal differences,
there
were human rights violations that were dealt with by the ICC, and your court does the same.
You are right, because international crime is human rights violations. That's what we can say. We are not trying individuals who committed massive crime or crime against humanity. We are dealing with states that does not respect human rights in the conduct of certain matters.
The 2007-2008 post-election violence in Kenya left, according to Human Rights Watch, 1,100 dead, 650,000 people displaced, and numerous sexual crimes were committed, but in most cases without any legal records or investigations. The victims are still waiting for justice. A natural question is, what, if anything, has the African court done about it?
The redress we can give them will be against the state for human rights violations. Like, I can take an example, like if rebels commit massive crime, you cannot go against the rebels individually, but you can go against the state for the fact that they cannot stop these actions of the rebels against individuals. So now the parties before the African court will be now the individual, the victim, and the state against which they have filed a case.
But if the state, and in this case Kenya, decides not to cooperate, what happens then?
There is no mechanism as such to oblige the state to comply with the decision.
Another long-running human rights controversy in Africa is Darfur, and the crimes committed there made Sudan's President Omar al-Bashir the first sitting head of state wanted by the International Criminal Court. He's been charged with genocide, war crimes and crimes against humanity committed in Darfur. Al-Bashir visited South Africa, a signatory to the ICC, in June 2015, but the government ignored the court's arrest warrant and allowed him to leave the country. It was a public display of disrespect for the International Criminal Court. Should the South African authorities have detained him at that time when they had the chance, when he was there?
I think it's the political decision of the South African state. So,
but you are a judge and you're an African, so you must have an opinion on this, no?
I cannot have really an opinion as such on this because I don't know the circumstances that lead the South African to comply with the request of the ICC.
How does the African Court of Human and People's Rights, how is it able to fight for those rights if it is essentially, as you seem to be saying, at the mercy of the member states who seem unwilling to give up much of their power in this regard?
Our mandate is not different from the European Court on Human Rights or the Inter-American Court on Human Rights. You have not a force, like a police force, to oblige the state to comply. But I think that a responsible state, the state, the vision to respect the human rights, I think that that state has to comply with the decision of the International Court.
But going forward will be difficult unless the court is wholeheartedly supported by the African states, something Justice Ben Kyoko, the vice president of the court, says needs to be addressed.
One of the recurring issues regarding institutions on the continent is lack of sufficient resources, both human and material. That's one. The second one is the mandate of some of these institutions are limited. And sometimes from the perspective of states, the argument is that they don't have the wherewithal to give these institutions all the resources that they require, particularly financial.
One of the most recent verdicts handed down by the African Court dealt with the electoral system in Côte d'Ivoire. The ruling stated that the Republic of Côte d'Ivoire has violated its commitment to establish an independent and impartial electoral agency as required by the African Charter on Democracy. The case was filed by a human rights group. The court ordered Côte d'Ivoire to form an independent electoral agency with members of the opposition as well as the government represented. The big question is, will the government comply with the ruling? Then what?
In terms of the protocol, the responsibility for execution of decisions of the court lies on the Executive Council, which is Ministers of Foreign Affairs on behalf of the Assembly of Heads of State and Government. And what the court does then is to report to the Executive Council whenever there's been failure to comply with the decision of the Union. And remember that this is also the structure of other international tribunals. I mean, there is no international tribunal that has the police and other enforcement measures that can force states to implement the decisions. So it tends to rely on the undertakings that member states have made and the commitments they have made, and on their goodwill as well. And I think states generally don't want to be embarrassed. I mean, in the particular case of Côte d'Ivoire, the Democracy Charter, Article 17, is very clear, as well as the ECOWAS, protocol on democracy.
Well, We contacted the Prime Minister's office in the Ivory Coast, and they categorically refused to comment on this decision. Can you tell us if the African Court has had any contact with the government in Ivory Coast since then?
No, it has not, and normally the court does not. The judgment is issued, it is transmitted to the government, to the parties concerned, as well as to the African Union and to the Executive Council of the African Union.
In Nigeria in 2015, people in the southeast of the country repeatedly took to the streets to demand autonomy for Biafra. According to an investigation by Amnesty International, Nigerian security forces carried out, quote, executions and violence resulting in the deaths of at least 150 peaceful protesters.
All hail Biafra! Biafra will help you!
The investigation also allegedly revealed hundreds of arbitrary arrests, including the detention of victims who were picked up in hospitals and then tortured. Nigeria doesn't allow individuals to file charges directly to the African Court, but the Vice President suggests there may be a way around that. Nigeria is not one of those 7 states that allows direct access to the court from NGOs and individuals. So if one of them were to try to take this case up with you, they wouldn't be able to. Is that right?
Yeah. One of the issues we consider is what we call personal jurisdiction, and Nigeria would have to be one of the countries that has filed the declaration for the case to be referred to us by NGOs or individuals. The other way of referring the case to the court is through the African Commission on Human and People's Rights. The possibility of a state referring a case against another state is very remote. It's very, very unlikely that a state would refer a case to the court against another state.
Because it wouldn't be in their interests, right?
Well,
if the accusation, I mean, in the case of the clashes in Biafra, if the state, as you say, is unlikely to bring this case up, and human rights groups and individuals are essentially not allowed to, because Nigeria is not one of those countries that allow it. So where does that leave us?
As I said, if the case was taken to the African Commission on Human Rights, because for case
would they be in a position to?
They would be, because all the African countries have ratified the African Charter, and the African Commission has been set up by the African Charter, and therefore a case can be taken to the African Commission against any African state. Now, if the African Commission on Human Rights decides in their wisdom to refer the case to the court, then the court could deal with it. But personally, of course, I'm not aware of the issue you've raised about Biafra. But certainly, if it was referred to the commission and the commission decided to either deal with it or refer it to the court, I think it could be addressed.
There are a number of other regional African courts throughout the continent, at least half a dozen. There's ECOWAS for West Africa. There's the Court for Commissar, East and Southern Africa. There's ECAS for Central Africa, SADC for Southern Africa. I could go on. How do these? What is the African court, your courts, supposed to do that these courts cannot? And it does seem like there's too many courts.
Most of these courts were set up as integration courts to deal with issues that would arise within the process of economic and political integration. And the ECOWAS court, for example, has that mandate. In addition, it has a mandate on human rights. The East African Court of Justice, similar mandate. But I think it's important to realize that for the regional and international courts, they cannot handle all the cases that arise. And therefore, at the primary level, the national courts are very, very important. In the case of West Africa, a case can be taken to the national level or to the ECOWAS court. But there may also be cases that, specifically on issues of human rights, need to come to the African Court, because the African Court is specializing on one particular issue, which is human rights, whereas ECOWAS has a much wider mandate. And therefore, I would not agree with the assertion that there are too many courts on the continent. When you look at it from the perspective of the mandate each of these courts has.
How does the court maintain judicial independence if it is essentially seen to be at the mercy of member states and the power that they are willing, or as the case may be, not willing to give up?
I'm not sure I understand how the independence of the court is affected in any way by.
Well, let me put it another way. How is the court able to enforce many of these decisions if it needs the cooperation of the member states every time?
Let me maybe look at it this way, that any international court that you can think of, talk of, for example, the International Criminal Court, it is funded by the state parties, and it requires the cooperation of states even to, for example, arrest individuals. The International Court of Justice is funded by member states. So it's most of the international courts and regional courts are based on the same concept, that you are funded by member states, but at the same time you have independence and impartiality ensured through the founding instrument. And at the national level, for example, judges are paid for by government, but they are independent. And therefore, independence is something very, very important for judges. I think I can't think of a judge that would agree that their independence as a judge and the ability to make independent decisions can be subject to any other thing. You look at the law, you look at the facts, that's it.
Justice Ben Kyoko, thank you very much for talking to Al Jazeera.
Thank you, Hassan.